Hello everybody and welcome to our webinar on CGT issues relating to the main residence exemption. For those that don't know me, my name is Adrian Bailey. I'm one of the principals of Cleary Hall and I'll be moderating the webinar today, which Kim Barnes from our Brisbane office will be presenting. I'll introduce Kim soon. But first, for those that haven't used the system before or perhaps just want a reminder, you should be able to see some options over onto the right-hand side of your screen. One of which is a files button. If you click on that, you can download the presentation from today in a PDF form. We'll also be sending that to you in a feedback email at the end of the presentation if you don't get a chance to download it. There should also be a chat option. If you have questions during the presentation, feel free to put them into the chat box and I'll ask them at an appropriate time. There will be time at the end of the presentation, but we'll also be taking questions during the presentation. So if you've got queries, fire them in and we'll do our best to answer them. I have presented this webinar before for an external body, and I did notice that there were a lot of questions in relation, obviously, to particular scenarios or particular client issues with the main residence exemption. If we don't get a chance to properly address them today, we'll come back to you separately on that. So we'll give it our best today, but usually there's a bit more information that we'll need to get from you to give you some proper thoughts on whether you get the main residence exemption. At the end of the presentation today, I mentioned the feedback email. We take all feedback on board. If you could take the time to complete that, please, be much appreciated. And one of the questions is what topics you may like to see. All of our topics come from requests, so we're always happy to get some topics mentioned so that we can think about them and present on them. So as I said, if you could take the time to complete that feedback survey, that would be much appreciated. We will be holding one further webinar towards the end of December. Obviously, it's a busy time of year for everybody, juggling work and social life. But we will be running something that's very likely to be a year in review or a recap of some of the major things that happened during the calendar year in our world. So Kim Barnes, who's going to present for us today. Many of you will have seen Kim present before, both on webinars, and those that have had the chance to get along to our face-to-face workshops would have seen Kim present at them. She's going to take over from now, and she's going to tell us all about some of the main issues relating to the main residence exemption and CGT.
Good morning, everybody, and as Adrian said, welcome to today's webinar. So we're going to have a look at the issues that impact on the main resident exemption. The main resident exemption is commonly used by clients as it's always applicable to their principal place of residence, which is usually their family home. Substantial wealth can exist in this property. However, there are a number of issues and considerations that may impact that eligibility of claiming the exemption, which we're going to have a look at today in this webinar. So today we're going to discuss the basic concepts of the main resident exemption, the 6-year rule and how it can apply to a client's circumstances. We're going to have a look at Airbnb and how this can affect a person's eligibility for the main resident exemption and whether it's a good idea to use your principal place of residence as an Airbnb. And if you do, what kind of implications this may have on sale dates. We're also going to discuss the impact of a person changing their tax residency, and because there are intricate rules that do apply to this. And finally, we're going to have a look at granny flat arrangements and how this again might affect a person's eligibility to claim the main residence exemption. So subdivision 118B of the Income Tax Assessment Act deals with the main resident exemption. There are over 40 different sections in this subdivision, so the intricacies of this exemption are quite vast. So section 118-110 deals with the basic case of the exemption, and this section says that any capital gain or loss from a CGT event relating to a CGT asset that is a dwelling or your ownership interest is disregarded if, firstly, you're an individual, secondly, that the dwelling was your main resident throughout your ownership period, and that interest didn't pass to you as a beneficiary in, or you didn't acquire it as a trustee of the estate of a deceased person. A person cannot choose not to use it. Therefore, if there was a capital loss, the main residence exemption is going to apply anyway, and you won't be able to carry forward that loss. whilst the basic case doesn't allow for the exemption to apply to a main residence that was acquired from a deceased estate, there are special rules that we won't go into today deeply in section 118-195 that may cover if you've inherited it and then it's your principal place of residence. Again, let's look at some exceptions. So section 118-110 doesn't apply if at the CGT event time, the person is an excluded foreign resident or a foreign resident who doesn't satisfy the life's event test. We're going to discuss the application and meaning of these words a bit further on in the webinar, but it was useful just to sort of touch on it briefly now. So if we go on and have a look at, well, what is a dwelling? Well, section 118-115 says that a dwelling is a unit of accommodation that is a building or contained in a building and consists wholly or mainly of residential accommodation. It's also a unit of accommodation that could be a caravan, houseboat, or other mobile home, and it includes any land immediately under the unit of accommodation. Section 118-120 doesn't not include adjacent land, so that is that 2 hectare rule, which we'll discuss now. So this carve out in the section provides that adjacent land to the dwelling is adjacent land if it was primarily used for private or domestic purposes in association with the dwelling. It provides that the maximum area of the adjacent land covered by the main resident exemption is 2 hectares. Less the land that's immediately below the dwelling or under the dwelling. So this is what we refer to as the 2 hectare rule. So if a person's principal place of residence extends beyond that 2 hectares, there's going to be a proportionate calculation to determine the amount of capital proceeds that can have the main resident exemption apply. And on the remainder, the normal capital gains tax rules are going to apply. A simple way to approach this calculation is on a land mass of the property. So if the property was 4 hectares, half would be exempt and half would have the normal CGT rules apply. That doesn't always have the best capital gains outcome for the client if predominantly the value is in the home. So you can look at an alternative method to approaching this by getting a valuation of the property and trying to have it value the land and the land that's beyond the 2 hectares. It may give a better tax result in the end. So then if we have a look at, well, what is ownership interest? So section 118-130 says that the meaning of ownership in interest in land or dwelling is for land that you have the legal or equitable interest in it or a right to occupy the property. For a dwelling that's not a flat or home unit, that legal or equitable interest in the land on which it is erected, or again, a license or right to occupy it. For a flat or a home unit, you've got a legal equitable interest in the stratum unit or a license or right to occupy, or a share in a company that owns a legal and equitable interest in the land that gives it the right to occupy. So that's where we talk about the old school company titles, is what that point 3 is really trying to get at. What this means is that although a trust can't access the main residence exemption, if it is a beneficiary's main residence, the beneficiary has a right to occupy it, and it can be documented in a formal long-term lease. There could be room to have a portion of the main residence or a portion of the capital proceeds exempt. It's really crucial in those circumstances, though, to have written documentation about a long-term lease, so you can make it clear that there is that right to occupy or that equitable interest in the land. So that is one way to sort of circumvent the fact that you're not an individual, and it's something that people who do own their main residence in trust can have a look at doing. So we move on to, well, when does the ownership interest commence and when does it end? It's just in the usual course of when you cease to live there. It's not the date of contract for when most CGT events actually occur, and it's usually going to be on the settlement date of the purchase or the sale. The only time that might not be right is if there has been a right to occupy given early on either the sale or purchase side of things. So if we have a look at, well, what is a main residence and how do we determine if it is a taxpayer's main residence? The Commissioner provides the view that a dwelling is generally considered to be your main residence if you and your family live in it, your personal belongings are in it, it's the address that your mail is delivered to, it's your address on the electoral roll, all your services, gas, electricity, telephone are all in your name and hooked up at the place. It may also be relevant the length of time you intend to stay in the dwelling and the intention of whether you intended to occupy it as your home. So if we get into the nitty-gritty of the 6-year rule and its application, Section 118-145 of the Income Tax Assessment Act provides an ability to allow the taxpayer to treat a place as their main residence, even if they're absent from the property. So this section provides that if a dwelling ceases to be your main residence, you may choose to continue to do so, to treat it as your main residence. As long as the property isn't being used to produce assessable income, there's an indefinite period where this can apply. So secondly, however, if the dwelling has been used to produce assessable income, then the maximum period of time that a person can choose to treat the property as their main residence is 6 years. It should be noted that this section doesn't apply to compulsory acquisition cases. So what are the requirements of the 6-year rule? It's important to note that if a taxpayer chooses to treat one residence as their main residence, they can't treat any other dwelling as their main residence. There is an exception if Section 118-140 applies, being the change of absence, the change of main residence, but there's a 6-month rule there. The choice can be made retrospectively, so you don't have to choose at the time of where you're living or occupying. So if we look briefly at the 6-month rule, this applies where a taxpayer has acquired an ownership interest in a dwelling that is to become their main residence, but they still also own their old main residence. Both dwellings can be treated as the taxpayer's main residence for a period of 6 months. So this allows buyers to purchase their new home if they haven't yet sold their own old home. But it's important to note that that rule will no longer apply if the taxpayer uses that old residence to produce income, so that couldn't help there. So if we have a look at just a vanilla case of the application of the 6-year rule, so if we consider here a taxpayer who has purchased a home, he lived in that home for 5 years, he then rented it out after that 5-year period for 5 years. So the ownership period here we have is 10 years. Because of the application of the 6-year rule, he'll be able to get the full exemption provided that he chose to treat that residence as his main residence and didn't have another main residence. So if we look at a more what we call a vanilla case variation, so here we're going to have a taxpayer who purchased a home and he lived in it for 1 year. He then rented that property out for a further 5 years, moved back in for a year, and then rented it out for 5 years. So again, we've got a total ownership period of 12 years here. And because the 6-year rule actually allows you to have more than one 6-year period, as long as there's a break there in between, the whole exemption is going to apply again. So on the sale of the property, the taxpayer could choose to elect to have the property as his main residence that entire time, and there'll be no capital gains tax payable on sale.
Hi, Kim. Before you go on, could you just go back 2 slides? Just got a question here for you on your vanilla example.
Yep.
So in this example, what happens if he has not re-established it as his home for 7 years, not 5?
We will get to that shortly, but if it's been 7 years, you can still choose to treat the first 6 years as your main residence. And there's going to be a proportionate calculation, which I'll show you a little bit further, to calculate what portion of it will be free and what capital gains tax you do have to pay once it's extended beyond that 6 years.
Okay, thanks. That's all for now.
So if we now consider the first circumstances, but instead the taxpayer didn't choose to apply the 6-year rule, So section 118-185 provides that the taxpayer only gets a partial exemption if the dwelling was your main residence during only part of the ownership period. So this partial exemption is calculated by using that formula on the screen, and it effectively looks at the capital gain or loss times the non-main residence days, so the days that it wasn't your main residence, over the total ownership period, so the number of days in that total ownership period. So if we put that formula into an example, here someone has acquired a property for $500,000, they rented it for 2 years, they resided in it for 3 years. So one of the key things here is that this person didn't live in it first, they rented it first, so you couldn't rely on the 6-year rule here. So this person then sold the property for $800,000. Here we're going to have a $300,000 capital gain. And by using that formula on the screen, we can see that $120,000 would be included as a capital gain as their assessable income. There would be obviously the normal capital gains rules that would apply in the ordinary course of that. So here's where we get to what happens if we exceed that 6-year absence. So section 118-185 applies. And so this allows a proportionate sort of calculation to occur. So this allows a taxpayer to treat the first 6 years of it as being a rental as their main residence. So if we consider the example on the screen, we have a taxpayer who purchased a property in 2020 and he moved in and lived in it for the next 3 years. At the end of that 3-year period, he sold out and rented it. He sold the property in 2030, so for exactly 7 years, it was rented out. There's a $300,000 gain, so what do we actually do with that gain? So section 118-145 allows you to treat that first 6 years of rental as your main residence. So then it's that similar calculation. So we're going to have the $300,000 gain divided by the total non-main residence days over the total ownership period. So here we'd have $30,000 included as a capital gain. So what we can sort of really see here is that the 6-year absent rule is quite a good tool for taxpayers to have who are selling their main residence. It can assist in mitigating any capital gain that might occur on the sale of a property.
Kim, just another question for you before you move on. How long would you have to live in it after buying it before renting it out? Could you live in the property for a few months instead of 1 year?
It all comes down to your intention. Obviously, the shorter the period, the harder it is to try and establish that it was your main residence and that it was your intention for it to be your main residence. There's no set guideline, but at the end of the day, it's going to come down to the evidence on hand and what you can sort of prove if there was ever going to be an issue on it. I would usually say, 6 months at a minimum. And that doesn't consider, what stamp duty consequences you might have if you move out sooner than that. So, these situations can get tricky. If we now consider...
Sorry, Kim.
Oh, yeah.
Just realised I put myself on mute. Can you go back to the earlier slide, please? Just another question for you on that example. In this example, don't you need to get a market value for when it was first rented in 2023?
No, there's no need for a market valuation to occur in those circumstances. It's treated on the total capital gain, not what the market value was when you started producing that income.
Thanks, Kim. That's all for now.
So if we move on to sort of the next example to explain how it can get tricky. Here we've got the original main residence of the taxpayer has now been rented out and the taxpayer has now acquired a new property. The original main residence was sold less than 6 months after the new main residence was acquired. However, the 6-month rule carves out property if it was rented, so we can't rely on the 6-month rule about changing principal places of residence. So we can't use this to treat both properties as the main residence of the taxpayer. As you can't have more than one main residence under the 6-year rule, the taxpayer is going to need to make a choice as to which place to treat as their main residence. If the taxpayer chooses the new property, then section 118-185 is going to apply on the sale of the old property. And if they choose the old property, then section 118-185 is going to apply on the sale of the new property. So depending on what they choose is depending on when that proportionate calculation is going to occur. And we need to use that formula. So that covers the 6-year rule. So we'll go on to discuss renting the property. Is Airbnb a good idea? So the section that governs this is 118-190. And this section provides that a taxpayer would only get a partial exemption if the main residence exemption would apply otherwise. The property or the main residence has been used for the purpose of producing assessable income. And if you had incurred interest on money borrowed to acquire the dwelling, you could have deducted that interest. In these circumstances, a partial exemption would apply. So let's look at, well, what is used for income producing purposes. So this looks at whether a particular part of the house is set aside exclusively as a place of business, is clearly identifiable as a place of business, and is not readily suitable or adaptable for use for private or domestic purposes. If a person's renting out part of their house or all of their house as an Airbnb, it's going to be used, it's going to be income producing purpose. So then if we consider amount that is reasonable, so Taxation Determination 1999 of 66 provides insights on the factors that should be taken into account in determining an amount that is reasonable in applying subsection 118-192. So this determination provides that it is usually calculated on the total percentage of the floor area of the house that was used for those income producing purposes. And it also takes into account the time that that part of the property was used for income producing purposes. In certain circumstances, it might be appropriate to attribute a higher or lower value to the other floor areas, but the taxpayer would need to show why that was going to occur and what the proportionate value of each area would be. But so generally it's going to be on the floor area of the home. If we move on to the impact of tax residency, so back to the basic case, section 118-110 defines an excluded foreign person to be if you're a foreign resident at the time and the continuous period you've been a foreign resident is more than 6 years. And it's also will carve out a foreign resident who doesn't satisfy the life events test. So if that is a foreign resident who's been a foreign resident for less than 6 years and doesn't have one of the following events occur for them. So the life events test is foreign resident for less than 6 years and the taxpayer's spouse or child under 18 has had a terminal medical condition during the period. There's been a death of either the taxpayer's spouse or child under 18 during that period, or the CGT event happens because of divorce or separation. So as previously discussed, an excluded foreign resident or a foreign resident who does not satisfy the life events test will not be able to claim the main resident exemption at all. There's no proportionate calculation for this, and the entire capital gain or loss will be dealt with in the ordinary course of the capital gains tax rules. What does this mean practically? If you're a foreign resident and you sell your main residence, you get no exemption, and you also have no access to the 50% CGT discount. So changing your tax residency can have really adverse consequences if you're looking to sell what was once your family home. If we then consider granny flat...
Sorry, Kim, before we get too far, can you go back to that example that we had the earlier query on? Because there's been a couple come in about market value. If you go back to where it was main residence and then rented out. So just to clarify from everybody, keep going. So this one. So with this, you take the market value at the time it was first used for rental purposes under section 118-145. So I think that's where a few people are getting confused about market value. And so in terms of the calculation that you end up doing, it's not clear on the slide, obviously, but that's assuming that the market value was taken into account in calculating the $300,000 gain. So hopefully that clears everything up for everybody.
All right, so we're on to granny flat arrangements. So generally there's two circumstances, two main circumstances where granny flat arrangements are used. So we're going to have a look at, in the case of elderly relatives using a granny flat in the principal place of residence, and where a granny flat's being used for renting for assessable income. So if we first consider elderly relatives, in these circumstances, these arrangements are normally private or domestic in nature, and therefore there should be no concerns on the sale on receiving the full main residence exemption. A question is often asked about, well, what if the elderly relatives were paying some sort of money to live there? Generally, it would still be considered private and domestic, and that would be more payment of board. And so it's not going to affect the main residence exemption as long as it was reasonable. If we then consider rental for assessable income, so this is where you're renting the granny flat to a third-party person, completely arm's length, we need to come back and have a look at the partial exemption in section 118-190. So this would mean that there's only going to be a partial exemption on the sale of the property, not the full exemption that would apply if it hadn't been used for assessable purposes, income producing purposes. And lastly, we're going to have a look at just quickly the CGT exemption on granny flat arrangements now. So there's no CGT when a granny flat arrangement is now entered into, varied or terminated pursuant to subdivision 137A, and this is from 1st of July 2021. So this applies in situations where an individual is eligible for the pension, or there is a disability that's going to last more than 12 months and that person needs assistance in their day-to-day life and most day-to-day activities. It does have to be between the parties, and it does have to be recorded in writing, and the arrangement can't be commercial in nature. So where all of those tests are met, there's no CGT when you're entering into those granny flat arrangements or varying them. So that can be, a big key thing now if your elderly relative is coming to live in your property. So it was a nice, short and sweet webinar today to cover those, key issues with the main residence exemption. So we do have time to answer any more questions if there are any.
Just while we're waiting for any further queries, just to confirm, yes, this session is recorded and will be available both at the Cleary Hall YouTube channel and also uploaded to our website. It'll go live on YouTube later today. The website probably next week sometimes. I think the link will be updated there. As I mentioned earlier, feedback surveys will be distributed. If you could complete those would be fantastic, including any future topics. And also, if you haven't had the opportunity to do so, there'll be a copy of the presentation attached to that. Let's give a couple of minutes or so, or a minute or so for any queries to come in. All right, Kim. What about if you're constructing a new home to live in and then sell it afterwards? Any particular rules to bear in mind re CGT?
There are particular rules about how long you can take to construct that home. Off the top of my head, I believe it was 2 years, but you can't quote me on that number. You do need to show that it's going to be, you do also have to live in the home. So if you're constructing a home to live in, but you have never lived in it, you're going to struggle to access the main residence exemption on it. You do actually have to move into it.
I think that'd be one of the key points, because there is a case tribunal matter where they didn't actually move in. So yeah, you do have to actually take residence in it once it's completed. It has to be within a reasonable period.
Yeah.
In terms of the another query for you, Kim, so you don't need to re-establish your residence to benefit from the 6-year exemption rule?
Not as long as you haven't extended beyond that 6 years. So you don't have to re-establish it once it's been rented out. As long as it's before that 6-year period, you get that full exemption.
And more a comment and then another query for you. Often the practical problem is getting the market valuations that need to go back numerous years.
Yeah, there's definitely a practical problem there.
Question, can you please shed some light if the client already has one PPR and building another on vacant land, let's say took 15 months from buying land to moving into the new home?
I think the key sort of question there is, at what point in time did they move in and was it a reasonable? I can't remember the sections off the top of my head, but there is something that deals with, construction of a new home. But
we'll come back to you separately on that one. Another query for you, Kim. Do you have to use the main residence exemption? For example, if it's going to be a loss, can you take the loss?
You do have to use the main residence exemption, so you can't carry forward that loss. There's no choice on it. If the property had been rented out, you've got the opportunity there not to use the 6-year rule. So you could try and get like a partial exemption, also a use partial loss. But yeah, you don't have the choice. You have to use it.
Okay, well, we're going to close it off there. Thanks for everyone's questions. Kunal, we'll come back to you separately on your query. We'll need a little bit more information from you because it's a little bit hypothetical. As I said, if you could complete the feedback surveys when you get them, and thank you for your attendance and good luck for the rest of the year.